be discussing HUD Section 3, American Indian History and Law. Joining us tonight, we have, as you know, CoachKrewkut. We got Chief Raymond L. Watson, Tomahawks of Fauna Americas. We got Phoenix Moon. We got Terry Vo, and we might have some other guests joining us as well. If I introduce ourselves,
anyone particular Tomahawk or?
Yeah. Everybody can go when they're ready.
Aquanese, that is TCNTU Families, Raymond Two Hawks, Mashipag Narragansett Tribe, and also Director General for the Federation of Aboriginal Nations of the Americas. Very blessed to be here tonight and hopefully being able to share some things that are of interest to you all.
Halito, Smith Phoenix, I am here. Hope everything is going well for everybody. Everything is healthy in Indian country.
Peace. This is Terry Bow, also known as Wakai.
And yours truly, CoachKrewkut. We screaming live, about to get this work in. Also have some more people coming in, but we'll get everybody in. As everyone come in, we'll let them introduce themselves.
Yeah, please like, share. We're dealing with some real serious information tonight. Please get this information to your peoples across the country. This is for all our American peoples. We're dealing with some serious laws, some serious resources that have been available to us for over 50 years. All right, so please take notes, follow along with us. We will be making a series of this, but we're going to begin. So please be on point for this good info.
All right, Chief Two Hawks, would you like to begin? And
Sure. So I just want to give some context for what I'm sharing this evening. This is a part of the information that the Federation of Aboriginal Nations of the Americas shares when we go through our orientation with new nations that are coming in. And what it is kind of just a timeline of some of the more pertinent policies that relate to American Aboriginal law, which is going to include certain things that are going to fit Indian law, but it's going to be much more encompassing because Aboriginal law is incorporating elements of international law as well as federal domestic law. So it's going to start with elements that deal with the U.S., and what we should keep in mind is that prior to any elements dealing with the U.S., there was, of course, the colonial powers. So when you're looking, and this is what we always say in FANA, when you're looking for your genealogy and things of that nature, you can't start with the U.S. The U.S. is very late in the game. That's after all of the issues going on between the colonists before they decide to create the U.S. and the Indian tribes that are here. And I think as I start to get into it, you kind of get a picture of why things transpired the way they did in terms of the United States independence and all of that sort of good stuff. So with that context, and are the screenshots up on the page? Will they be able to see everything? Okay, very good. All right, so I'm going to start first with the first element that's up there. And there are going to be some things that you could probably plug in if you've been doing your research. Once again, these are just some of the more pertinent things, but there are tons of other legal situations that affect American Aborigine. But we're going to start, and once again, we're talking the U.S. with the Declaration of Independence in 1776, where there's a clause in it where it's accusing the British Crown of inciting insurrections against the colonists by the quote-unquote merciless Indian savages who they acknowledge as the inhabitants of the frontier. So what this should tell you right there is that there was still some good relations between the British Crown and local Indian tribes while the colonists were going ahead and starting their insurrection and getting upset with the British Crown. And from our understanding, a lot of that had to do with the fact that a lot of the things that were going on between the colonists and the Indian tribes weren't necessarily sanctioned by the British Crown. They were just doing them in the name of the Crown. And once the Crown found out what was happening to a lot of the Indian nations over here, the Crown pretty much told them, hey, look, you know, you guys can't do that. We have treaties with these nations. Those are their lands. You have to give them back. You're supposed to be paying them taxes on the things that you bring out of there, so you have to pay them that, and you all can't continue with this behavior that you're doing because it reflects badly upon the Crown. And that's where the Declaration of Independence comes from. Because, you know, they had slaughtered us, they had enslaved us in a lot of instances, shipped us out into the Caribbean, and there was no way on earth that these people all the way across the water were going to tell them that they had to go back on any of that. So here comes the Declaration of Independence in 1776, and once again, they're accusing the British Crown of inciting the Indians, who they're calling merciless Indian savages, to be instrumental to what they're telling them. We move on to 1781, 5 years later, with Article 3 of the Articles of Confederation. And here they acknowledge that there are free inhabitants of the land that are around, and these free inhabitants are not necessarily considered underneath the articles. They're just kind of mentioned. So you're seeing from the very beginning, Indian tribes and Indian people are not citizens of the United States when the U.S. starts. When the U.S. of A. starts, Indians are not citizens, and we'll see how they become citizens as we go on. Article 1, Section 8 of the Constitution, and there's a few different elements of the Constitution that deal with Indians, particularly Indians not taxed. But Article 1, Section 8 of the Constitution, and this is in 1789, it designates the power to regulate commerce with the Indian tribes exclusively to Congress. So anytime you're dealing with Indian tribes that are in their proper status, that should show you right there it's a nation-to-nation relationship, because by law, Congress is the one that has to deal with them. Indian tribes, when they're in their proper status, are strictly a federal sort of jurisdiction, and strictly dealing with Congress in terms of how they negotiate and deal with them. Let's move on to 1794, the Treaty of Amity, Commerce, and Navigation between His Britannic Majesty and the United States of America. This is more formally known as the Jay Treaty. And this guaranteed the right to free trade and travel for Indians between the United States and Canada, which was then the territory of Great Britain. So this is dealing really with the U.S. and Great Britain in terms of how they're establishing their relationships with each other. And the Jay Treaty is one of the things that, once again, still applies to Indian tribes today. The right to travel freely without imposition of posts or anything like that when you're going between the territories of Canada and the United States. Now we jump forward to 1819. This is McCullough versus Maryland. 17 U.S., 4 weeks, 316, 421. And in there, Chief Justice John Marshall makes it clear that Congress can do whatever is necessary and proper unless it violates the letter and the spirit of the Constitution. Congress can only exercise things that are necessary and proper, and are granted by the Constitution. So when we look ahead to things like the Indian Citizenship Act, the 14th Amendment, they explicitly exclude tribal Indians from citizenship. Thus, any argument making Indian citizens would be necessary and proper is negated. We'll touch base upon those earlier, but basically what it's saying is Congress can only do what it's given power by the Constitution to do. And if the Constitution is saying that Indians aren't, well, what power does Congress then to have to confer something on them when it's clear in the Constitution that they're not? Moving forward to 1830, we have the Indian Removal Act. And this led to treaties that forced most Eastern Indian tribes to the west. So a lot of the Eastern tribes were forced out west due to the Indian Removal Act. And this is where a lot of the treaties, the first treaties with the U.S. start to come into play. There's treaties before that, but some of the first treaties in the U.S. start to come into play around this time as they're forcing tribes out west, taking the lands that are here. And once again, they need these treaties with this tribe to show that they have a lawful right to even be in those lands, because they're still operating at this point under the treaties that the tribes have with the British Crown. Once they kind of break away from the British Crown, they're still subject to those treaties, and we'll start to see sort of the things that they put into place to kind of pull themselves from out of that as we move forward in the presentation. 1884, we have Elk versus Wilkins, 112 U.S. 94 103-04. Elk is a voters' rights case in which the pivotal issue was citizenship. Mr. Elk had been born in a tribal relationship. He had lost his tribal identity, and then he had merged into the Omaha, Nebraska, and white population. The court determined that he was a foreigner, and that as a foreigner, he had to meet the uniform rules established for naturalization to gain citizenship and voters' rights. So once again, you're seeing Indians are not citizens. By constitutional law, Indians are not citizens. And this gentleman, Mr. Elk, trying to assimilate and trying to kind of meld into the white population, which is what a lot of the ancestors did. If they were lighter skinned and if they could pass, a lot of them would attempt to pass because it was a lot less detrimental. You could come off of the reservation. Being stuck on the reservation was not a good thing, and you wouldn't be treated as harshly. It was not a good thing to be an Indian at this time. The court relied heavily on the debate of the 1866 Civil Rights Act, 14th Amendment, and the Senate Judiciary Report of 1870 in arriving at this decision. Once again, the 14th Amendment is not including Indians as citizens at that time. The 14th Amendment not only put citizenship for former slaves beyond the reach of further legislation, but it also constitutionalized the exclusion of tribal Indians from citizenship. So it was there before. The 14th Amendment is really kind of codifying the fact that Indians are not citizens. And then we move on at the end of this first slide to 1887, the General Allotment Act, which is more commonly known as the Dawes Act. And this now is seeking to extinguish tribal sovereignty, erase reservation boundaries, and force assimilation because they realize now, well, wait a minute, we're stuck now. If these people aren't citizens, then we have to honor all of these treaties. And we really don't want to honor these treaties with these people. We've been treating them like they're animals and like they're property. How are we going to sit here now and treat them like they're eye to eye with us? So you have the Dawes Act coming in, and they're really trying to assimilate and force assimilation upon Indians at this time. I'm moving on to slide 2 right now. So this is where things get interesting. Okay, very good. Because remember, Indians are not citizens. So therefore, they're not subject to taxation. They're not subject to all of these things. But this is a growing United States. They need to, they need land. They need opportunity for the population, for all of the immigrant populations that are here. So now you have the Racial Integrity Act of 1924. And with this act, this is really coming out of the stuff that was going on with Virginia with Walter Plecker. This requires that a racial description of every person be recorded at birth, and it divides society into only 2 classifications, white and colored. So if you're white or you're colored, then you're not an Indian, in which case none of what we just discussed about Indians not being citizens applies to you because you're colored, and colored is a designation that the U.S. has created for its citizens. They make everyone either white or colored, and this is where a lot of the ancestors who they were calling quote-unquote Negro Indians become colored and get disenfranchised from being Indians at this point. Now, simultaneously, in the same year that they're doing the Racial Integrity Act, they do the Indian Citizenship Act of 1924, which is a Snyder Act. And this is where Congress just basically confers U.S. citizenship on all Indians. Now, we have to keep in mind everything that's going on right now is all commercial. And the example I always like to give, if anyone's familiar with like credit cards and credit debt and all that, if you get a letter in the mail or notice that a credit card company or a debtor says you owe them $5,000, and if you don't do anything, write them back and let them know that you don't owe them those $5,000, then by law you owe them those $5,000 because you did not contest the commercial claim that they were making against you. So if we take that same sort of mindset and understand that citizenship is really a commercial claim, the authority to tax you for being in these lands, that's what citizenship is all about, then you understand that the Indian Citizenship Act of 1924, the Snyder Act, is really them making a commercial claim that Indians are under their jurisdiction commercially as a result of being citizens and therefore able to be taxed. Within this Citizenship Act, they give some sort of language that says as long as it doesn't interfere with their right to tribal property. So really what they were saying in this is that Indians have dual citizenship with the U.S., and with their Indian tribe, but of course you have to be in a proper commercial status by law to be considered an Indian tribe. And most of us at this time are not. We're not down anywhere written as anything other than Negroes, coloreds, all of that craziness that's going on, because it's all a commercial game. So they're getting all of the commercial documents together. They're making all of the commercial claims which aren't being rebutted that show that whether you're a Negro Indian, whether you're a stereotypical Indian, you're under our commercial jurisdiction. And since you're our citizens now, there's no more international rights, there's no more human rights, there's only civil rights. And civil rights are which are permissions that your superior is going to give you, and your superior at this point is the United States. So now they've got pretty much all the Indians right where they want them. Now comes the 1935 Indian Reorganization Act, the IRA. And this is when federal Indian policy changes, as this law is enacted to protect the remaining Indian land base, encourage Indian tribes to adopt constitutions, and engage self-government. So what you see here is a little over 10 years after they put all of the Indians under jurisdiction, it's now okay for the Indians to be Indians again. You know, they can live off on their land base. You know, they can adopt constitutions, and they can be domestic dependent nations, not sovereign nations, but domestic dependent, because they're all citizens and therefore inferior to the U.S. So, you know, everything that you want to do now, and you can self-govern as well. Why? Because if you get out of line, we're just going to lock you up because you're under federal jurisdiction. So within a 10 to 11 year period, you see that they go from being very hostile to Indians to wanting to encourage them to pursue self-identity and to kind of protect their lands and all of that sort of stuff. 1953, we have Public Law 280. This is very important. Y'all want this up because in terms of Indian... Okay. So Public Law...
My apologies, y'all. My apologies. That's on my side. 1 second.
Okay, very good. So 1953, you have Public Law 280. This is very interesting, something y'all want to look up. This is the law that gave 6 states criminal jurisdiction and civil jurisdiction over Indian reservations. Now think about that. They needed a law in 280 to give states criminal jurisdiction, which means prior to Public Law 280 and outside of those 6 states, Indians are federal jurisdiction, strictly. They needed to enact the law to give the states jurisdiction, and that law had to be signed off on by tribes, and most often it was with tribes who had like very extensive reservations where, you know, it could be a 3 to 4 hour drive from the state boundary over the reservation to get to where the town is, in which case, you know, it might be very hard for federal agents to get there. If they need assistance, whatever the case may be, it would just be very hard if they don't have a lot of federal agents that are pretty much working out situations with the states where the states can come in and assist them with law enforcement. But just to keep in mind, states do not, by law, have jurisdiction over Indians unless they are under the jurisdiction of a Public Law 280 relationship, or unless the Indian tribe itself has given over jurisdiction to the state, which has occurred in many instances. 1956, we have the relocation program, where this is what offered job training and housing assistance to Indians who would leave the reservation for urban areas. And this is where a lot of the Indians kind of come off the res, go into urban areas like Chicago, New York. This is where you see a lot of, they'll call it, heading north and, you know, seeking job opportunities and all of that sort of stuff. But really this was directed at a lot of the Indians that were out there, trying to get them to assimilate. Because staying on the reservation is still not helping them to kill the Indian. That's really what the goal was, to assimilate the Indian to the point where he doesn't exist anymore. And this is something that's of great interest at this time in terms of assimilation and getting them away from this whole perspective of being sovereign. State and Local Fiscal Assistance Act of 1972 provides support and funding for local Indian tribes with recognized governing bodies that perform substantial governmental functions. 1978, this is very pertinent to us here in Rhode Island. This is the Rhode Island Indian Claim Settlement Act. This was dealing specifically with the Narragansett Indian tribe. My cousin's down in South County. But you have to pay attention to that language because we didn't have any R's in our language, so there's really no such thing as a Narragansett. That's an English colonial corruption of the term so that they can claim ownership over that title and once again hold them into subjection. So that's why you see my tribe is the Meshipog Nahagansett. We didn't have any R's. But this Rhode Island Claim Settlement Act, it extinguishes Aboriginal land title for state and federally recognized American Indian tribes in Rhode Island and Indians, but only those existing in a U.S. citizenship status. So when Meshipog approached the state initially after we did our filings of our trust and all that and met with representatives from the governor and the attorney general's office, they tried to bring up this Rhode Island Indian Claim Settlement Act, but we explained to them that we've repatriated to our own jurisdiction, so that doesn't apply to us. We're not approaching this situation as U.S. citizens. We're approaching this situation as tribal citizens of our various tribes. And that's when they tried to offer us federal recognition, which is the next element you see on there, which comes out in 1983. But, of course, as you can see with the 1978 Act, there is no federal recognition for Indian tribes in Rhode Island anymore. So that should show you just how powerful the things that we're moving in and the understanding we have of the law is. Even though they passed something stating that they couldn't do it anymore, the state attempted to offer it to us, hoping that they could somehow get us back under their jurisdiction, which, of course, we very respectfully declined. Federal recognition in 1983, this is where Congress enacted procedures for establishing that an American Indian group exists as a tribe, providing for administrative recognition. And it's very important to remember that because administrative is all business, so it's commercial. So this is a commercial recognition for Indian tribes, but a recognition. And if you look up that term recognition, you'll see that it's different from acknowledgement. Acknowledgement is basically stating, okay, it is what it is. Recognition is agreeing to give someone permission to do something on your behalf. So when an Indian tribe gets federally recognized by the U.S. federal government, basically what it's saying is that the government is giving us permission to be Indians on these federal reserve lands. You sign over all your lands into a trust with the federal government. Congress, once again, because it deals with the Indian tribes, becomes your caretakers. And now you're under federal jurisdiction with the U.S., and in exchange for that, you'll get some money. They might allow you to open up a casino. But all of this really doesn't do the people much good because they then build relationships with specific families. One of the things that they force is a popular vote system. And then, you know, with any popular vote system, whoever can get the most votes rules. So you can have families where a situation happens where individuals are adopted into the tribe, and then all of the adopted individuals then side with one particular group. Now they have the majority of the votes in the tribe, and now they start to oppress the people who aren't with the corruption that's going on. And this is what happens a lot of times with federally recognized tribes. The more traditional form of government that was utilized by several different nations, I won't say all of them, but several of them, was a clan system in which each clan had a clan chief that spoke on behalf of the entire clan, which is the family. So therefore, it didn't matter how big your family is, your family gets one say in what's going on. Now, when it comes to distribution of resources and things of that nature, of course, if my clan is much bigger than everyone's, then the resources should be distributed appropriately. But every family got a voice, so there was no bullying of smaller families or clans. Every clan had a voice in the tribe. The federal recognition process provides for administrative recognition, which puts tribes underneath the jurisdiction of the federal government, which then forces upon them a popular vote system, which then leads to all sorts of corruptions because it's really modeled after what's going on in the U.S., and we can clearly see what's going on with the electoral and political leadership in the U.S. at this time. So things are pretty quiet on that, on the Aboriginal policy side for Indians in the U.S. because you've got them all under federal recognition, and if any of us have had experiences, we know that this causes division amongst families. Certain parts of the families are on, certain parts of the families aren't on. Certain families are getting resources from the tribe, certain aren't. And you've got all of the chaos going on amongst the tribes. So there's really no need for the U.S. to get involved any further. The tribes are really tearing themselves apart, chasing after the crumbs that they can get through federal recognition. 2007 comes the United Nations Declaration on the Rights of Indigenous People, UNDRIP. This delineates and defines the individual and collective rights of indigenous peoples, including their ownership rights to cultural and ceremonial expression, identity, language, employment, health, education, and other issues. It emphasizes the rights of indigenous peoples to maintain and strengthen their own institutions, cultures, and traditions, and to pursue their development in keeping with their own needs and aspirations. So UNDRIP is a tremendous document because it's the first sort of international law document that's acknowledging that indigenous people have inherent rights that have to be respected and have to be respected on the same level as human rights too. I'm sure you all know the U.S. was not a signatory to that because, once again, that brings up this whole issue of what the real relationship is between Indian tribes and the U.S., and they don't even want to deal with that. They've got these Indians either federally recognized or as United States citizens, so why on earth would they sign on to something that would give these people some more rights? Nevertheless, this is an international doctrine, and it is something that can be employed by Indian tribes when they're in their proper status as foreign nations to the U.S., but sharing same lands as the U.S. Let's move on to Kacheri versus Salazar. Once again, this is coming out of my fantastic cousins here in Rhode Island, the Narragansett Indian tribe. This is 2009, and in this ruled that the phrase of tribes now under federal jurisdiction in the Indian Reorganization Act, and this is going back to 1935, referred only to those tribes that are federally recognized when the act is passed. It ruled that the federal government could not take land into trust from the Narragansett or any other tribes that had been federally recognized and or acquired land after 1934. So what basically happens is after 34 with the Indian Reorganization Act, they start getting all of these tribes to get federally recognized, in my opinion, knowing damn well that they don't have any lawful authority to do it. The Narragansetts, being federally recognized, attempted to challenge the state's right. And you might want to look this up, the Narragansett smoke shop raid, I want to say it was early 2000s. The exact year is escaping me at this time. But pretty much the Narragansetts attempted to set up a tax-free smoke shop on a state road down in the area near the reservation, claiming to be sovereign, which of course they weren't. They were under federal recognition. And further, they were in a 280 type of relationship with the state of Rhode Island, asking the state troopers to provide assistance to them in case they needed help because they didn't have their own tribal force. So you can't sign an agreement like that and then turn around and decide that you're going to sell tax-free cigarettes and not even on the reservation on the state land. It was a very ugly situation. The governor at the time, Donald Kacheri, sent in the state troopers. You can look it up on YouTube. You know, people got, accosted, slammed, arrested, all of that sort of stuff. But they were advised not to fight the case because they didn't have the jurisdiction to do what they were trying to do. And they went ahead and fought it anyway, and this was the outcome for it. So for a lot of the federally recognized tribes who have gotten federally recognized after 34 or 35, this is terrible. Basically, they don't have any lands in trust, but they signed away their rights to their lands. And they've been receiving money for it and all that sort of stuff. So you're kind of just Indians without any land, stuck in a situation where you're subject to a government that's foreign to you that you've given your lands over to. For tribes that are in fauna's position, however, this is fantastic because what it basically says to us is, okay, since that was unlawful, then any of the tribes that were in our territories that did that, that was not lawful on the part of the federal government. So right now the feds don't have any lawful claim in terms of a trust relationship with any of the lands that are in our ancestral lands. So this is just strengthening everything we've been saying. We're basically saying, well, if you all didn't take it into trust and we did, then what's your argument against how these lands are under our jurisdiction? And they don't have one. So for very often they were just ignoring us, and more recently they've really started to kind of buckle down and meet with us a little bit more to figure out exactly how we want to work this out. Because the law is the law. And that's one of the things I want to impress upon everyone. The law is the law. So everything that they've done thus far has been lawful because we have not rebutted it correctly. We have not said to them, through the proper procedures that everyone else uses, that doesn't apply to us. And since we haven't done that, all of these things apply to us, but now we start to see their plan unraveling with something like Kateri versus Salazar. So I'm going to move on to the third and final slide now. On this third slide, we have 3 elements before I close out my portion of the discussion this evening, and I thank you all for bearing with me thus far. We have ADRIP, the American Declaration for the Rights of Indigenous People. Now, this is instituted by the Organization of American States, which has much more binding relationship upon the United States than the United Nations does. With the ADRIP, it offers specific protection for indigenous peoples in North America, Mexico, Central and South America, and the Caribbean. So this is the importance of making sure that you're lawfully establishing the separate jurisdiction from the United States. Because when you're not in the United States, but you're still in the lands that they're calling Rhode Island, New York, North Carolina, Virginia, then you're in North America, not the United States. So if you're in North America, then of course ADRIP applies to you, because you're not within the jurisdiction of the U.S., you're within this landmass that they're now referring to as North America, and that's why you see FONA's official name is the Federation of Aboriginal Nations of the Americas, because these are all the Americas: North America, Central America, South America, the Caribbean, Mexico, whatever name they want to put on them, they're all the Americas. America, the United States of America, singular, is how they co-opted the name to use it for themselves, which is how they started calling themselves Americans. But we all should be properly saying that we're from the Americas. America is something they created for themselves. Let them have it. We're from the Americas. It's so much more broad and encompassing than this little thing that they're calling America. So you have ADRIP, and once again, it affirms the right of self-determination, rights to education, health, self-government, culture, lands, territories, and natural resources, and it includes provisions that address the particular situation of indigenous peoples in the Americas, including protections for those living in voluntary isolation and those affected by a state's internal armed conflict. So it's pretty comprehensive. If you haven't gone through it, you definitely should. But once again, it's only going to apply once you've properly identified that you have a jurisdiction and a blood heritage that predates all of this craziness going on with the U.S. And this is very important. We want to be very cognizant of this, because the last thing we do want is people popping up who haven't fully established a blood connection that predates forming Indian tribes and claiming these rights, because then it's going to come out when they get into a federal court. It might work on a state level, but when they get into a federal court and the feds start pulling out all of the federal laws, they're going to basically say you don't have the standing to invoke these sorts of things, and that's when the black identity extremist label comes in. Because you're claiming things that are right, you just don't have the jurisdiction or the standing to claim them, and now you're looked at as an enemy of the state because you're talking about things that you shouldn't be talking about, perhaps even informing people, but informing people who by law don't have the right to enforce them. It's looked at as, once again, insurrection against the U.S., which is the same thing they started off with when they did the Declaration of Independence, insurrection by the Indians. So it's the same arguments going on, same things going on. They broke away from Britain because we were being insurrecting against them. If you're moving in these space and claiming these things, but you're not in your proper status, they look at it as insurrection. And the same way they started this country is the same way they're going to keep it up, getting rid of the hostile Indians, the merciless savages. Last 2 things I want to look at, because these are strictly from this year. And a lot of times, especially when you're dealing with like people coming from a Moorish background, one of the first things that comes out when they're debating is, well, the treaties aren't intact anymore. And it's not that the treaties aren't intact, it's that once again they've conferred a U.S. citizenship upon Indians, and they haven't rebutted that claim properly. So it's not that the treaties aren't intact, it's that you don't have the standing and the jurisdiction to enforce them. You cannot enforce a treaty against your own country. So if you are a citizen of the U.S., you cannot claim treaty rights against the U.S. You're a citizen of it. You are subject to the rules and regulations that the U.S. has. In order to enforce a treaty right, you need to show that you're a nation that had a treaty with the U.S., which once again goes to blood lineage. as a Narragansett, misnomer Narragansett, I cannot claim the treaty that the Poconokeets have with the Pilgrims. I'm not a Pokanoket. It doesn't apply to me. Treaties are specific contracts between parties. The same way when you sign for your home and get a mortgage, that contract is between you and the bank, which means Joe Schmo down the street can't come in and start using your house because he's not party to that contract. So in that same manner, we cannot, just as general Indians, claim Indian treaties unless we have shown specifically that we are blood connected to the people who are party to those treaties. So if I use myself for an example, I descend from a couple of pre-colonial chiefs as well as ones that were involved with when the whole federal recognition got started. So I tie back to a Canonicus and a Mayantonomi who were signing treaties with the British Crown in the 1600s. And those are my direct ancestors. So now I can go into any court of law and say, well, those were my ancestors. Therefore, I'm a party to those treaties, and so is my family. Now I can enforce because I'm showing that I was here before the U.S., and I can show the pattern based upon the different laws that we just discussed, showing basically the strategy that was used to pull me out of that and why I have a right to go back. It's not just as simple as I've been here for a while. It's I've been here for a while. These are my people. These are the treaties that we're party to. These are the laws that say that you have to honor my treaties, and these are the repercussions if you don't. It's that in-depth when we're getting into this, and it's not something that we want to play around with. It's not something that we want to half-step with, and it's not something that we want to try to take shortcuts with. We want to make sure to do it right because I can tell you from personal experience and from the experience of the nations that are involved in fauna, when you do it right, they respect it. Because like I said, the law is the law. And they're not going to be able to hide from the law when you're in your proper status and when you're knowledgeable about how to apply it. So I just wanted to give that preface as we go into these last two elements that the treaties are still in play. One of the things that's very interesting is that if you look at President Trump, as kind of rude and crude as he can be, he put a Supreme Court justice on the court who has been siding with Indian treaty law. His name is Gorsuch. So you want to look up these two elements because they're from this year. The first being the Washington State Department of Licensing versus Cougar Den, Inc., once again in 2019, and this affirms the right to travel provision of the 1855 treaty between the United States and the Yakama Nation of Indians. So right there, you can see it's a treaty between the U.S. and the Yakama, and this gentleman who's involved in this is a Yakama. So he's pointing specifically to a treaty that his nation has with the U.S. and says, look, I have this right. And the court pretty much decided that that provision preempts the state's fuel tax as applied to Cougar Den's importation of fuel by public highway for sale within the reservation. So because those are reservation lands, and because he's traveling on them, and because he has a treaty that he's party to, the U.S. has to, or the Washington State Department of Licensing, the state, has to acknowledge the treaty. It can't ignore the treaty and do what it wants because it's subject to federal law, and treaties are federal jurisdiction. So the states, when they confer jurisdiction with commerce to over the Indian tribes, to Congress, they gave all of the power to the feds. So the feds are the final say. The state can try what it wants, but what you would do, an Indian would then take them to federal court outside of their jurisdiction and apply the federal laws that apply to you. And the federal courts are going to look at it from a federal perspective. And once again, not even states are above the law. They're going to move according to how the law says. But once again, you have to be party and you have to be in the jurisdiction and in the standing to do it. And then the last one I want to look at is Forever versus Wyoming, which again is 2019. This held that hunting rights for the Crow tribe under the 19th century treaty that they have did not expire when Wyoming became a state. And that's one of the things that the states pretty much argue. Well, once we became a state, then those hunting rights and all that, they went away because, you know, we're a state now. And that's not what treaties say at all. But once again, if you're not forcing the issue with them, if you're not in your proper status to argue the matter with them, if you don't have the standing to be able to even bring it up in court, then you're not getting anywhere. You're a U.S. citizen, and once again, you cannot argue treaty rights against your own nation. On top of that, if you're going to argue treaty rights, it has to be done in the proper jurisdiction. And the only jurisdiction to do treaty rights is going to be an Article 3 jurisdiction, because that's the article of the United States Constitution in which treaties are addressed. So if you're in an Article 2 or an Article 4 jurisdiction, then you can't hear treaty rights. And they're not going to tell you that you're in the wrong jurisdiction. They're just going to tell you that the court can't address these matters, or you don't have the standing, or whatever the case may be. But the fact of the matter is you're not even in the right jurisdiction to bring it up, and they know you don't know that, so they're just going to move right on past you. There's one other element that I want to bring up. It's not on the slide, but everyone should be looking in at this. If you follow the fauna page, we shared it earlier today. It's the case of Carpenter versus Murphy. This hinges on a murder case early in American history, and there's been various interpretation of tribal land rights as it applies to it. But the Supreme Court just decided not to hear it because basically what it's showing is that there's really no federal jurisdiction over the reservation land in Oklahoma. And because there's really no federal jurisdiction, the Supreme Court has asked the state to see if there's any provision within the state law that would show that the feds could have some jurisdiction over there. And of course, there's not going to be any, because that was never the case. When they signed these treaties, they weren't giving states anything. It was signing treaties with the U.S. government, and that was that. If there was no treaty, or if the U.S. government said, okay, those are Indian lands, then that's what they are. So this case is kind of unpulling that whole dirt that was hidden there. And the reason the Supreme Court doesn't want to acknowledge it, because once they acknowledge that, then it unravels everything else that the states have done that are not lawful. The only reason that we're able to challenge these things is if we understand the law and the history that happened to us. We can go in and scream about what physically happened to us or what emotionally happened to us all we want, and no one's going to care, because by law we're not in the proper status or standing to argue it. So we have to first be understanding of the history of the law that affects us. We then have the understanding of the proper processes in law to undo it. And then we have to be cognizant and knowledgeable about how to apply the law to protect ourselves, because ignorance of the law is never an excuse. If you do not know that this law is being violated, if you do not know how to protect your rights under the law, then you are subject to be chewed up and spit out, as has been happening to our people. And I think that this is good context as we begin the discussion about HUD Section 3, because by law, HUD Section 3 was put in place, but if we don't know about it, or if we never went and accessed it, or let them tell us that we couldn't access it because we didn't understand the law ourselves, well, that's no one's fault but our own, until we apply the law and hold them accountable for it. That's my rambling, a lot of talking. I'm happy to answer questions. I'm happy to wait till later, whatever y'all want to do, but that kind of should give everyone, and I know it's a lot of info, but just a historical context of the policies that impact American Aborigines from a lawful perspective.
Yo, Two Hawks, much appreciation. Yo, we appreciate you, man. Everything you just said, I think a lot of people could benefit from that information. This video, to everyone listening, it will be available through multiple platforms soon. But definitely we appreciate everyone's presence. Phoenix Moon, you with us?
Yes, sir. I am here.
Right, yo, Phoenix, you ready to go?
Very, yes, I am. Two Hawks, I just wanted to thank you. That was a very thorough presentation. It's good that the people have access to that information. They'll be able to refer to it on the playback. Halito, everyone. So, HUD Section 3. Let's start with the Fair Housing Act, a.k.a. the Civil Rights Act of 1968. We have
one
a
second,
clip
one
with...
second, Felix. People can't see the video. I'm trying to log into it. It says this is a private video and may only be viewed by people that the video owner selected, and there's people in the section asking how to do it.
I'm, I'm doing it from my page also, and it's also public.
All right. Sheesh. Maybe it's just me then. Finish this watch party. Yeah, everything's private. I can't see it.
You went to crew
All right,
cut?
I'll try to figure it out.
You went to crew cut?
Yeah, I was on the crew cut. I went to Phoenix's as well.
I actually have a watch party going. It shouldn't be private. It's public.
Right.
Crew cut Bridges.
Right.
And it says Bad Boy underneath the name.
Right. Crew cut. We're on Facebook.
Yeah.
We're on Facebook. You
Yep.
in?
Facebook. Yep.
All right.
No, not yet. But I don't want to interrupt everyone, so I'll try to figure it out on my own. I don't want to
if you send me a friend request, I accept it. Cause I know it shouldn't be. It should be available for everyone.
All right.
All right, now Phoenix,
All right,
one more time. One more time, Phoenix. Come on, hit me one more time. Where we going?
Well, I wanted to show that clip regarding the 1968 Civil Rights Act,
Okay.
April 11th, 1968.
Okay.
Also known as the Fair Housing Act.
I got it right here. Let me. Okay. I want to make sure they can hear it. No, they can't hear it. Let me stop this. I got it where I can play it. Just 1 second. I had a little hiccup over here, but everything's good.
Mm-hmm.
Stop that there. Okay, and let's see. All right. I'm sorry about that, everyone. I want to make sure that brother hit me with I was too busy paying attention to what he was saying. I didn't do nothing. He was giving it to me. All right, here we go right here with the video. Fly in and play.
When the Fair Housing Act was voted on and passed in 1968, it was a landmark piece of legislation. Why? People had been trying for a long time before that. It was in and out of committee. It was very contentious. It was the assassination of Dr. Martin Luther King.
Yeah, crew cut on. We're not able to see it on the screen right now.
Really provided the impetus to do it.
I see
because
it.
all of a sudden, a lot of people who were in opposition began to recognize, this is a real problem. Maybe I didn't think it was a problem because it wasn't affecting me, but it really is affecting me, because if we're unfair to anybody, ultimately we're unfair to everybody.
If one says that I am not good enough to live next door to him, if one says that I am not good enough to eat at a lunch counter, or to have a good, decent job, or to go to school with him merely because of my race, he is saying consciously or unconsciously that I do not deserve to exist.
We got the worst, nastiest mail we got on any piece of legislation on the Fair Housing Act. And we were unable to move it. We ran into this. First, there was a big issue. It got to be called Mrs. Murphy's boarding house. And we shouldn't subject Mrs. Murphy to this.
They were frightened. They were full of the stereotypical kinds of things. They felt bad people would come to the home.
They assassinated Martin Luther King. You can imagine what that was like. Horrible, horrible, horrible. During this time, the city started exploding. Man, oh man, it was fires and everything all over town. And we got the bill passed anyway. Probably because he was killed, we got the bill out of the committee. But we knew we had a lot of work to do to reunite our country and get back on a solid track. No question about it.
It became really very clear to a progressive president like Lyndon Johnson that the federal government needed to create a focal point for thinking about the cities, thinking about civil rights, thinking about economic justice, thinking about concentrated poverty.
Word came from Capitol Hill that Congress had passed and sent to the White House the Civil Rights Act of 1968. Included in the measure was a landmark open housing bill, which, when fully effective, would forbid discrimination in approximately 80% of all housing offered for rent or for sale in the United States.
Now with this bill, the voice of justice speaks again. It proclaims that fair housing for all human beings who live in this country is now a part of the American way of life.
They say law is a good teacher. I think the Fair Housing Act has taught a couple of generations of Americans, at least leaders, that this is part of the American dream, to end harsh racial segregation.
But as a HUD secretary, I had to wonder how many people in America who didn't have a lawyer friend helping them get resettled or work near a job would not have had the resources to know what to do. I mean, it seems so elementary to have fair housing, but HUD is out there day in and day out trying to enforce our fair housing laws and trying to make sure that people get treated fairly when they go rent or buy.
I do not exaggerate when I say that the proudest moments of my presidency have been times such as this, when I have signed into law the promises of a century.
I still have a dream. One day men will no longer see racial integration as a problem, but as an opportunity to participate in the beauty of diversity.
We back, Phoenix. Can you hear me?
Yes. Okay. So now, the Fair Housing Act. This is what they disguise. This is what it's commonly called. And that has direct result with the Housing and Urban Development, which Ben Carson, in the first clip, that is who is the head of it now. The problem that we are having and what we have been having is not being into our proper status, the same as Tomahawk was indicating, notifying people. And with that being said, they have now changed it. The original 1968, where it says that, you know, the rights of Indians, of course it talks about the riots. And again, this is a direct result over the mayhem that was happening all over the place with the riots and the American Indians, okay? They have what's called single subject matter. So if you are proposing a law to take care of the elephants, you cannot include the giraffe and the falcons in this particular law. What I mean by that is from Title I all the way to the end of it, and Title VIII is which was the fair housing portion of it, goes back to the rights of Indians. So what we have to challenge, and some of the challenges that we are facing again because we are not in our proper status, is the fact that they have changed these words, and we are still being discriminated against by the very same law that's been here for the last 52 years for us to change things economically, completely, change our infrastructure and the way our communities are run and dealt with now. That has not happened. And then you have the people that are getting all the contracts from housing and urban development. Can you show those article of the two gentlemen that were, well, not gentlemen, the two men that were arrested for the funds that were being stolen from these particular programs? And these programs are not limited to just American Indians or Native Americans, for lack of a better word. This is for everybody that is in public housing, regardless of what it is, your race. So these funds have been withheld from people, and it's been available, like I said, since April 11th, 1968. And a lot of people don't know about it. Krewkut will be able to present that to you and show you that there's not a lot of people taking advantage of these opportunities. The HUD Section 3 specifically, that is not, the Section 8 is about the housing, but the HUD Section 3 talks directly about getting the contracts to be able to do business and be employed and have training and all sorts of things that will help people be self-sufficient and sustained. And there have been a lot of people that have been hiding this information.
You talking about the fake Indians?
Well, I don't want to say fake Indians, because now since they have changed part of Title 42, which has excerpts of the Fair Housing Act in it, they have removed American Indian and Negro.
No. I'm saying the article. I found it. I'm about to pull it up now. The fake Indian raking millions in contracts.
Yes, that is correct. That is correct.
I got
That
you.
is correct.
Make sure I'm pulling up the right stuff. Fly in.
So these are the people that are taking the funding. It's not the American Indian. It's not even what people know to be Native Americans. These are Europeans, and they are stealing. And several of them have just been indicted. I'm sure there will be more. But this is the things that are happening, and you're not getting any of this funding. So it's going to be very serious.
You want me to read it?
And critical. Yeah, please do. Can you please?
It says, in a bombshell report, the LA Times revealed the white men in almost every state have been falsely identifying as Native American or paying black people to serve as the front so they could make hundreds of millions through government contracts. That sounds like Section 3 to me.
Okay, stop right there. How do you falsely identify as a Native American, but you use black people to serve as the front? That should mean something to somebody. That's and this is a direct quote from the Los Angeles Times.
It sounds like Section 3 to me.
How would they be using so-called black people to get money as Native Americans, falsely identify as Native Americans, to get these contracts and completely dominate and shut out all of the people that are in every housing project that you know of anywhere in the USA, so-called United States? Anybody that has a Section 8 certificate is eligible for these programs. How many people do you see thriving in your community benefiting from any of these programs? Right, in the entire country. In the entire New York State metro area, 20, 30, 40 million people here, there is less than 100 people that have HUD Section 3 contracts. Less than 100 in a metro area such as Atlanta, a metro area, Charlotte, Chicago. Every last one of us knows somebody that qualifies for Section 8 and is having a hard time, and they may have a fairly decent job, but they still don't meet the median requirements, okay? And they still have other options as well, and are eligible for other programs through the same housing and urban development. And these instances have always been neglected. These opportunities have always been neglected the entire 52 years of the Civil Rights Act. Now, can you read a little more of that for me, please?
Sure. Government agencies in almost every state in the U.S. are reeling after the LA Times dropped a huge story detailing how white men in almost every state have been awarded million-dollar contracts from programs designated to promote minority-owned businesses. Through these tactics, companies have been able to rake in more than $300 million. Moreover, the LA Times admitted that that figure is almost certainly significantly higher than $300 million. While the LA Times report primarily focuses on white men who had either the biased claims to Native American heritage or claims to be part of a tribe that is not officially recognized, other news outlets have reported on fronting schemes where white men use a minority figurehead to secure millions in gains. Regardless of which method they use, these schemes was extraordinarily lucrative and in many cases were tied to corrupt government officials. The brother-in-law of Republican House Minority Leader Kevin McCarthy, William Wages, said he was 1/8 Cherokee. However, the LA Times looked through genealogy records and found that all his relatives were white dating back to 1850. And they just went back to 1850. Wages claims to be part of the Northern Cherokee Nation, which is not a real group. He made more than $7 million through his company. However, once the LA Times report came out, his company refused to recertify under California's Minority Business Program. I wonder why. Since the LA Times story came out, municipal and state governments have started revoking the contracts of companies that were owned by white men posing as Native Americans or fronted by someone from a non-white race. Rebecca Nagel, a Cherokee Nation community organizer, told the LA Times that the scams were damaging on multiple levels. They kept actual minority-owned businesses from accessing vital funds and contracts that kept them afloat while giving their white competitors a sizable advantage through lucrative no-bid deals. Now, they ain't have to bid. It takes those resources not just from our community, but from our communities of color, she said. It's really problematic. LA Times.
Now, this is from the Los Angeles Times, and this is under California. Whose territory is that? The lady that they're going to look to pretend that she's a strong black woman and deserves to be pandering for our vote, Kamala Harris? That's her hood. This goes down under every single gatekeeper's watch that too many people have faith in. And this is the result that comes out. Their hands are not clean at all. Not by a long shot. Their hands are not clean at all. There is another article also, a different perspective of the same atrocity with those particular brothers. And also you have Mr. Greg Russ. Do you have that? Can you play? Can you show that, please, Krewkut? You're back on. You're rolling again. You're rolling again. No, you're still there. You're still there.
All right, yeah, I got a lot. I
Yeah.
just got bamboozled. Look like I got spammed or something. I just got hit with every piece of spamming. I guess they thought it's not good, right? They spamming me right now. I'm getting spammed, y'all. I guess
Oh boy.
I don't have that. Yeah, if you can see what's flying through the preview screen right now. Hold on, let's see. Yeah, they hitting me hard. Let's see.
Hey, Crew Cut. Yo, you said you downloaded everything I emailed you, right?
Right, everything was sent.
Just run.
Yeah, but the last one.
Yeah, I think you.
I just got bombed. Like, I just got bombed. I just